Good morning. For those of you who don't know me, my name is Richard Creed. I help payment institutions, electronic money institutions, and challenger banks manage their legal risk so they can concentrate on growing good and profitable businesses. I founded Creed Solicitors, which is a boutique payments law firm which focuses primarily on the payment institution, electronic money institution, and challenger bank market. Creed Solicitors can draft and amend customer-facing terms, including to take into account the upcoming faster payment reimbursement requirement rules relating to app fraud, which we're obviously talking about today. We can draft your outsourcing agreements with third parties. We can review commercial contracts you enter into with your suppliers. We also provide external in-house services to PSPs and EMIs, and we act for buyers and sellers of payment institutions and electronic money institutions. So today we are going to be giving you an overview of the new FPS Reimbursement Rules, some information on how you can tell if a customer is a vulnerable customer or not. We shall run through some payment flows which fall inside of scope and outside of scope of the FPS Reimbursement Rules, including whether you operate the payment account model or the money remittance model, whether you use VIBANs, what the position is with regards to overseas payments. We'll run through some FX flows and some contractual wording you can put into your terms and conditions to protect yourself to the maximum extent possible. We'll also run through some upcoming deadlines and ways that we might be able to help you deal with this. These new rules are coming to force in just over a month's time. Quick disclaimer. This is intended to be an overview of the reimbursement rules. Every PSP model is slightly different, so please don't take it as firm legal advice. If you would like bespoke legal advice, please get in contact with us. You can email me, and my email address is at the bottom there. I also think Ariana's put a link in the chat, so you can book a 15-minute video call if there's anything coming out of this webinar, or any other legal matters that you would like to book with us. So, without further ado, the FPS reimbursement requirement. So, Section 3.1 of SD20 states that when a victim, so be the customer down here, reports a reimbursable FPS app scam payment to their sending PSP, up here, the sending PSP must reimburse the victim in full. Now, that is subject to a cap, and up until 2 days ago, we all thought that cap was £415,000. The payment systems regulator yesterday issued a consultation on reducing the cap to £85,000. That consultation is open until the 18th of September, so if you want to have your say on that, the more voices we have asking to reduce the cap, the better. So yeah, the cap hopefully will be £85,000. A PSP will have to reimburse its customer in the following circumstances. Firstly, its customer needs to be a consumer, and that's either, in this circumstance, an individual, a micro enterprise, or a charity. So if your customer is obviously a corporation and is larger than micro enterprise level, or is a large charity, then you don't have to reimburse them under these rules if they claim that they've been the victim of an app scam. So the customer, another requirement is that the customer uses the PSP to execute a payment via the faster payment system. No other system falls within these rules. You may be aware that CHAPS are considering changing their rules much in the same way as faster payment systems are intending to change their rules, but that is that's coming down the line. It's not impending imminently. I think the consultation on that will happen after these rules come into force. In addition, the payment has to be in GBP. If the payment is in any other currency, your customer can't get a successful claim in against you in relation to that. And another important point is that the GBP has to be sent from a relevant account that the customer has with its sending PSP. Now, this is important because if you have your account up here with your own financial institution and you only operate the money remittance model, you won't be sending money from an account that your customer has with you. That money will be sent from your own account that you have with your financial institution. Now, as I'm sure you're all aware, money remittance is a service whereby you transfer money on behalf of your client without payment accounts being used. If you send money via money remittance and it is GBP and it is via faster payments, then this actually won't fall within the rules. It's this credit transfer down here falls within the rules. So it has to be from your customer's payment account with you to a beneficiary account. Another requirement is that the beneficiary account that the money is sent to has to be not controlled by the consumer. Either this account is not who the consumer intended to pay, or the payment is not for the purpose that the consumer intended. In addition to that, the sending and the receiving accounts both have to be based within the UK. The consumer standard of caution has to not apply. We'll look at more into that in the coming slides. And obviously, the victim has to not be a party to the fraud or claiming fraudulently or dishonestly to have been defrauded. I think it's probably been spoken about quite a lot, but it's obviously going to be difficult for you to work out whether the consumer has been a party to the fraud or not if they are a professional fraudster. But if you suspect that, there are claims to there are means not pay out. The time limit that the claim has to be made within is 13 months, which is obviously a long time. Now, the definition of receiving PSP is also important. So receiving PSP is over here. Receiving PSP is the PSP that provides the relevant account into which the app scam payments are received. So who provides the account that this payment goes into. If you're a PSP which receives money which is subject to an app fraud claim, but you don't provide a relevant account for your customer, for example, because you operate the money remittance model, which we spoke about before, so the money probably goes into an account that the receiving PSP, well, this PSP has with its financial institution. If the money goes up here, then this financial institution that provides the PSP with its account is actually deemed to be the receiving PSP. You might also receive money from a customer or a third party and not credit it into this account because it's subject to a prior foreign exchange contract that you've entered into. Accordingly, the money hasn't been credited to this account that the beneficiary has. It's been credited into this account up here, which the PSP has with its own financial institution. Therefore, this financial institution is the receiving PSP and would have to send the reimbursable contribution amount to the sending PSP if the sending PSP has paid out to the consumer down here. Now, it's more likely than not that if your bank has to pay out as a receiving PSP due to your own business, that they will have gotten indemnity from you on a contractual basis in which they can claw that money back from you. Or they'll just say, listen, you're going to have to pay us back, otherwise we're going to shut down your accounts from a practical point of view. Clearly, this is in relation to your business, and this financial institution that provides you with your accounts should not be liable for it. Time for repayment. So the sending PSP must reimburse the victim within 5 business days of the reported scam. However, you are able to stop the clock for as long as is necessary to receive information for one of the following reasons. That's either to gather information from the consumer or their agent to assess whether the claim is a reimbursable FPS app scam. You could gather information from the receiving PSP over here to verify that an agent of the customer that's claiming on its behalf actually has authority to submit a legitimate claim, to gather additional information from the consumer about whether they were vulnerable or not. and where the sending PSP has evidence of fraud on the part of the person who made the app claim, to gather additional information either from the receiving PSP, which is over here, or from law enforcement, or from other relevant parties. For scams involving multiple relevant PSPs, you can gather information from all of the PSPs involved. I can't see in any circumstance people actually paying out within the 5 business days, because you will always want to try and gather further information before paying out. But there is a long stop date you must be aware of, which is 35 business days from when the claim was reported. And on the reimbursable contribution amount, which I spoke about before, being sent from the receiving PSP to the sending PSP, there's a 50-50 split as a default between the sending PSP and the receiving PSP. Now, if the sending PSP decides to send more than the cap, so if the cap's 85k and the sending PSP is someone like Barclays or Nationwide, who decide they're going to reimburse all of the money because it's good for their reputation, you as receiving PSP actually only have to compensate 50% of the cap. You don't have to compensate 50% of what the sending PSP sends down to the consumer. That says 415, but as we discussed, should be 85k, fingers crossed, as a result of the consultation paper. I'll talk a bit more about the consumer standard of caution. So PSPs are not required to reimburse an FPS app scam payment where the consumer standard of caution exception applies. So this applies where the sending PSP can demonstrate that the consumer who's made an app scam claim has, as a result of gross negligence, not complied with one or more of the following standards. Firstly, the consumer should have regard to any intervention made by the sending PSP, for example, confirmation of payee, and or by law enforcement or any competent national authority. This is why it's so important, even if you don't have to implement confirmation of payee, as it's one way of stopping an app scam payment. You should also have interruptions in your payment journeys online to check what the payment is for. I've certainly seen on my own bank that whenever I set up a new payee, they ask, who is it? Is it a company, a business, a friend, a colleague? And put suitable warnings in place in each circumstance. This is just one way of demonstrating gross negligence on behalf of your customer if you've interrupted the journey with appropriate warnings. In addition, the consumer should, upon learning or suspecting that they have fallen victim to an app scam, report the app scam payment promptly to their sending PSP. Now, I don't know how well that sits with the 13-month deadline that they've actually given people to complain, but you would imagine that if they wait 9 or 10 months, that's maybe one of several factors that might lead you to say that they've been grossly negligent. The consumer also has to respond to any reasonable and proportionate requests for information made by you as the sending PSP. If they don't do so, you can say that not to comply with the consumer standard of caution. They have to be grossly negligent in order to fall foul of that, but it's again another string to your bow of an argument. The consumer should, after making an app scam payment, consent to you reporting this app scam to the police on the consumer's behalf, or request that they directly report the details of the app scam to the police and any other appropriate authority. If they don't do that, then to me that's a sign of fraudulent activity, and that's another argument you can throw forward for not paying them back. So this consumer standard of caution does not apply if the victim was a vulnerable customer at the time they made at least one of the app scam payments, and this had a material impact on their ability to protect themselves from the scam. So ascertaining whether your customer is vulnerable is important. There is a £100 excess you can apply to app fraud payments. Obviously, it's not huge. If your client is vulnerable, then you can't apply that excess. And as we said before, the consumer standard of caution exception does not apply. So a vulnerable customer is someone who, due to their personal circumstances, is especially susceptible to harm, particularly when a firm is not acting with appropriate levels of care. You need to have implemented systems to ensure that you catch a vulnerable customer before they execute a payment. And this is all part of the Know Your Customer process. You need to keep an eye out for if there's been a change in their behavior, if they've made a request which is unusual or out of character, if they've mentioned anything about their personal circumstances, for example, in relation to their health or something that's going on in their personal lives that might indicate that they're vulnerable. Do they appear emotional, confused, or distressed? Or are there any indicators that might be under financial pressure? If you claim from a customer and need to assess, if you get a claim from a customer and need to assess whether they were vulnerable at the time the payment was executed, your staff which accept these claims should be well trained in order to assess this. Most likely it will come out when they explain to you the circumstances under which they sent the authorised push payment. However, this could be coaxed out of them by asking them if there's anything going on in their personal life at the time they made the payment, which made them particularly susceptible to falling for the scam. So your staff should be well trained so the customer does not have to keep explaining the same thing multiple times. You do need some assessment of vulnerability, as if they refuse to pay out and it goes to the Financial Ombudsman Service, they will look into whether this has been done. It's worth noting that the payment service regulations are going to be amended in time, we think, for the 7th of October 2024, so that you can delay a payment for up to 4 days if you think that the payment order was subject to fraud or dishonesty of a person other than the payer. We had someone contact us about 12 months ago who was in distress because they were the victim of a romance scam. They thought that they were communicating with Chris Martin from Coldplay and wanted to send money to America because apparently Chris wanted some help paying a legal claim in America he was involved with. I mean, this is exactly the type of scam that needed to be cut off at source. The bank in question was actually based in the Republic of Ireland, pleaded with her not to send the money. They probably should have refused to pay the money, but maybe wasn't. They were conflicted in that the customers get to do what they want to do with their own money. So it was a very complicated circumstance for the bank to have to deal with. In any event, that's obviously a very obvious app scam payment, but at least with these new amendments, you do have the tools to delay for a couple of days and decide what you're going to do. So what I'm going to do now is run through a few payment flows. And hopefully this will bring to life a little bit of what I've been saying. So this is PSP sends money using the money remittance model. So down here, we've got the customer or the alleged victim. They've obviously got their own bank account with their own bank. This is you, I presume you're all PSPs. You obviously have your own bank account with your own financial institution. On this side of the board, we've got the beneficiary's account, which is issued by the receiving PSP and held by the beneficiary or the sort of alleged or potential fraudster. So I explained earlier, the payments are only caught by the rules if a customer is persuaded to send money from their relevant account with the sending PSP. However, you can see from the schematic that the customer does not have an account with the PSP. PSPs may, for a variety of reasons, send GBP via faster payments on behalf of its customer, which does not debit a relevant account the customer has with the PSP. As I said before, the PSP may only have the money remittance permission and not provide its customers with a payment account, or the PSP may be sending GBP to another account after completion of an FX transaction. This is the payment here, GBP, faster payment systems, and obviously this is in the UK on both sides. So yeah, post FX transaction, the money might be sent directly to the beneficiary's account rather than being topped up to a payment account down here or an electronic money account if there is actually an account down here. So these payments do not fall within the FPS Reimbursement Rules. Put a big X through it because the consumer has not been persuaded to transfer money from the consumer's relevant account because the consumer either doesn't have one or it's an FX transaction or some other circumstance which is similar. And the PSP here as well would not be deemed to be a sending PSP, as the definition of sending PSP requires that the PSP provides a relevant account from which the FPS app scam payment was made. And this PSP isn't providing the relevant account. It's this financial institution up here. If you're on this side of the board and you're a PSP that received money, you should not, well, obviously, because this PSP hasn't had to reimburse the victim, hasn't had to say a reimbursable amount, you don't have to send a reimbursable contribution amount of 50% to the sending PSP. If you do get requests for information as a receiving PSP, you should find out what circumstances of the payment were and push back hard in the case that the sending PSP has misunderstood the rules. You could argue that if this PSP has actually compensated the customer, that was a voluntary payment and you shouldn't have to reimburse 50% of it. So what should you do? If this is your model, it's essential that you make clear in your terms and conditions with your customer how your model operates and in what circumstances, if any, you will compensate your customer and in what circumstances you won't compensate your customer. If you don't do this and your customer makes a claim for an app fraud, they'll be more disappointed than they otherwise would be if they've been informed when customers are and when customers aren't entitled to compensation. They'll also be more likely to refer their complaint to the Financial Ombudsman Service, which are completely free to do so. You don't want to spend time dealing with false claims if you don't have to. It takes up an awful lot of time and you have to deal with it very well to make sure you don't lose a case. If the payment is particularly high, you might want to get solicitors involved, which will obviously increase the price of defending it. There's also a small chance that the FOS might order you to pay compensation even when you don't have to, because they deem to be fair and reasonable in the circumstances. If your terms aren't clear and you haven't made it clear to your customer. Now, the Financial Ombudsman Service doesn't actually have to comply with the law. It's worth pointing out they have to do what they think is fair and reasonable in all the circumstances. As app fraud is very much foreseeable harm for your consumer if you don't put in place appropriate steps and you don't make very clear when you're going to compensate them when you're not, then it is conceivable that the Financial Ombudsman Service might order you to pay, even though technically within the rules you don't have to. It's worth pointing out that your terms shouldn't just say when you're going to reimburse and when you're not going to reimburse. If after an FX transaction is completed, you're not going to top up a payment account the customer has and you're going to send it directly via running remittance, your terms should very much say that that's the case, because you can't alter the facts after the case. You can't say, oh, well, it wasn't credited if your terms aren't 100% on that. Well, you can say it, but you got a much weaker case. So the next slide, similar to the previous slide, except that the customer is sending GBP via faster payments from its relevant account with the PSP. So down here, we've got the customer. It's got its bank account with its own bank. This is you, the PSP, and you've got your own account with your own financial institution. But importantly, the customer got his own account with you. And then on this side of the board, it's the beneficiary account, receiving PSP, and a beneficiary. So this type of payment would be executed where the PSP has a payment account permission or is an electronic money institution, and the customer's payment account or electronic money account is debited when the money is sent to the beneficiary account. So this is obviously GBP via the faster payment service, and this is in the UK, and this is in the UK. I know there's a lot of FX firms on the call, so if it is your policy that after an FX is completed, that the customer's payment account or its electronic money account is credited, or the money sent on to the third party, even if you've got the payment order beforehand, it's going to be pretty much immediate. This payment will still fall within the faster payment systems rules. And this PSP will be deemed to be the sending PSP. And if the customer is genuinely being the victim of an app scam, then the sending PSP will have to reimburse the customer the full amount of their losses, subject to whatever the cap may be. If you're on this side of the board and you're the receiving PSP, then you will have to pay the relevant contribution amount to the sending PSP, which, as we discussed, is a default of 50%. So what must you do? If you execute these types of payments, again, your terms and conditions should make very clear when you reimburse the customer and when you will not reimburse the customer. For example, you need to make it clear that you won't reimburse the customer if the payment is in a currency other than GBP, or if the payment is sent outside of the UK, or if actually the payment is up here and it's not sent from the customer's payment account. Otherwise, your customer will feel more dissatisfied and they're more likely to complain to the FOS. Again, you should make clear on your website when you will pay out and when you won't, on a page that gives customers tips on how to avoid app scams. So the next slide is when the PSP receives money, which is part of an app scam, which is credited to the beneficiary's account with the PSP. So in this slide, let's assume that the payment does fall within the FPS rules. It is, GBP via faster payments, sent from a relevant account belonging to the consumer. The sending PSP had reimbursed the customer with the reimbursable amount, and the money was sent to an account that the beneficiary has with the PSP. So in this circumstance, the PSP would be over here, would be deemed to be the receiving PSP in accordance with the rules, as it is the PSP which provided the relevant account into which the app scam payment was received. Accordingly, the receiving PSP will have to pay the relevant contribution amount to the sending PSP. So what should you do? Well, in your terms and conditions, I would recommend giving yourself the ability to freeze this money in your customer's account so you can try and claw back from the client any money that you have to pay across to the sending PSP. You should also insert an indemnity into your terms and conditions, allowing you to pursue your client if you have to pay a relevant contribution amount. Never put that in, relevant contribution amount. If you have to pay the relevant contribution amount to your sending PSP, you want an indemnity in here that says that, if PSP has to send the money to the sending PSP, then we can try and claw that money back from you. So it's obviously really important that your onboarding processes are as tight as possible. So you're not opening accounts for clients where fake IDs have been used. I know you're all doing this anyway to comply with the money laundering regulations, but just emphasizing the point. Knowing your client is obviously another essential component of the fight against app fraud. You need to understand why your client is seeking to open an account with your firm to receive GBP payments from the UK. So the next slide is where the PSP receives money, which is part of an app scam, which is credited to the PSP's payment account with the financial institution. So over here, again, this is an app scam. We've got sending PSP customer, its account. There's going to be a contribution amount over here. That's going to be paid. We're going to assume that. But instead of the money going down here, which was the previous slide, the money is going to go up here. This might happen if the PSP doesn't actually provide payment accounts to its customers, or if the PSP's customer, beneficiary here, enters into an FX contract prior to the money arriving with the PSP, and it wasn't intended to be credited to the beneficiary's payment account. In this circumstance, as the money has landed with the PSP's account with the financial institution, the PSP's financial institution up here, in my view, would be deemed to be the receiving PSP under the FPS Reimbursement Rules. There is an argument that unless each payment account the PSP provides, its client has its own VIBAN, then the money sent to the PSP always lands with the PSP's account with its financial institution. However, ultimately, if there's a dispute between the PSP's financial institution and the PSP, who is officially the receiving PSP, you want to have very clear terms demonstrating on what basis the money was received into the PSP's account with the financial institution. ultimately this might not matter very much if the PSP's financial institution has an indemnity between it and you relating to it receiving money in relation to the PSP's business, or if the PSP's relationship with the financial institution is so important that it would rather reimburse the financial institution than fall out with its, rather pay this money across itself than fall out with its own financial institution. So what you must do, if you're a provider of accounts to other PSPs, for example, up here, you should make it very clear in your terms that if you are required to compensate a sending PSP over here in relation to this PSP's business, then you will seek to get this money back from that PSP. You could consider putting in place a reserve account, much like card schemes do, from which you can deduct compensation amounts you have to pay to the sending PSPs relating to that PSP's business. If you're a PSP, you should insert in these terms between you and the beneficiary, again, the ability to freeze money in your customer's account down here. If you're of the belief that you've received money relating to an apps fraud claim, and include a contractual provision to be able to pursue the customer if you do have to pay compensation to the sending PSP, or if you do have to pay money up to your own PSP by way of an indemnity. So next slide is the payer sends money linked to the beneficiary's account with the PSP. Sorry, using a VIBAN linked to the beneficiary's account with a PSP. So over here, we've got obviously our customer. It's the customer's account with the sending PSP. There has been fraud. On the right-hand side of the schematic, this is you. You provide beneficiary accounts to your clients, which is we call the beneficiary or possibly the alleged fraudster. And there are VIBANs linked to those accounts. So if the sender sends money using a VIBAN and that VIBAN is linked to the beneficiary account down here, then the issuer of that payment account, in my view, is the receiving PSP that has to compensate the sending PSP if the sending PSP has compensated the customer over here. This is very similar to my previous slide. Now, I know sometimes this institution might be issuing VIBANs, and the money might actually go into this account. But if the VIBAN is very much linked to a customer down here and to this account, in my view, it's probably likely that this PSP will be the receiving PSP having to pay compensation to the sending PSP. I would say that the VIBAN structures are quite different and complicated, the ones that I've seen. So I would emphasize that I would need to look at your individual model to ascertain what your risks are in this regard. But this is sort of a generic overview. So yeah, what would you need to do is your terms and conditions should again give you the ability to freeze money in the beneficiary's account and be able to chase the customer if you do have to repay any money to the sending PSP. You should also make your onboarding processes as good as possible. What if the VIBAN is linked up here? This is a similar slide to the previous one, except the receiving PSP, in inverted commas, doesn't provide a payment account to the beneficiary. This is all the same. We've got the sending PSP and they've got their account with the customer and the money is reimbursed. So money's coming from here, but it goes up to here. Now, this might be the case if this PSP, again, only has the money remittance permission and money comes in using this VIBAN. So the payment system knows that the money should be credited to this account. And this PSP knows that it's linked to this PSP. And this PSP knows what customer it relates to, but there's actually no account down here. In this circumstance, I think that the top PSP up here would be the receiving PSP. Sorry, can't seem to spell. So again, you want to have the ability to freeze any money that you hold for the clients. You want to set an indemnity so you can chase them. So But in this circumstance, the main point is that this is the receiving PSP up here. So overseas payments. You'll see on this slide that there is one payment that's executed within the UK. So anything to this side is the UK, left-hand side. Anything to this side is non-UK. So we've got one payment executed within the UK here, and there's one payment which is overseas. That's okay. That's over here. So the risk is, I suppose, that your customer thinks that this is one big payment from them to the beneficiary. However, if your customer is actually a client of yours, it breaks down into two payments. So this one might be faster payment service in GBP. This one could be more likely another currency, euro, but it could potentially be GBP overseas. So the payment on the left-hand side here falls within the FPS Reimbursement Rules. So you'll see that the PSP on the left here will be sending the PSP, the middle PSP, the money. This payment over here is not within scope. Therefore, if your customer asks you to send money to a beneficiary overseas, and this was a scam, then as long as your customer had control of this account over here, then you will not have to reimburse your customer. Obviously, if a fraudster has a control of this account, then potentially you might have to reimburse the customer under this payment. But provided that this account, your client has control over the payment account, then you won't have to reimburse for the transaction on the non-UK transaction. Again, clarity in your T's and C's is very important. You should say that you won't reimburse for overseas payments. Otherwise, you won't be deemed to be transparent with your customers, and that's in breach of the consumer duty. Also, your client's more likely to bring a claim to the FOS if you're not being very clear with them from the outset. This slide is in relation to overseas payments, where you are, so non-UK is on this side, UK is on this side, but you're the receiving PSP here. So this is our PSP. This is the account with the customer. This is the sort of ultimate beneficiary account over here. And this is the initial sending bank. So you'll see that the UK PSP in the middle is receiving money from outside the UK. This payment is not in scope of the FPS rules. You see that the UK PSP is sending money within the UK. This payment is in scope of the FPS rules, with the middle PSP being deemed to be the sending PSP, and the receiving PSP being this person over here. So you should make clear in your terms and on your website which payments you will reimburse and which payments you won't. Otherwise, you won't be deemed to be transparent with your customers and in breach of the consumer duty. In addition, you're more likely to get a false claim. So on this slide, we're focusing on the payment in from the customer's own bank account or from a third-party bank account. You'll see here that we have the customer or third party down here. Doesn't matter which, and it's got its own bank account in GBP and in euro with its own bank. So you are over here, you're sort of a PSP stroke FX provider. This also applies for electronic money institutions as well. So if your client wants to enter into a euro to GBP payment, then they will be sending you either to their own account or to an account you hold with your own bank, euro. As we all know, euro doesn't fall within the faster payment scheme rules, so that will not fall within the rules at all. If the client wants to enter into a GBP to non-GBP, for example, euro, payment FX transaction with you, then they will most likely send GBP from their own bank account to either your account you have with your financial institution or their own account that they have with you. This payment obviously is within the faster payment rules because it's in GBP, obviously provided it's been sent from a UK account over here. and it's been sent in GBP, which obviously it has been if it's a GBP to euro transaction. Let me just have a look at this slide. Give me 2 seconds. So yes, if you're receiving money, then obviously if it's in euro, it's outside the FPS rules. If it's within GBP, then it is within the FPS rules. So you need to break the FX transaction down into its constituent payments. So sending money out post FX transaction, if it's a euro to GBP payment, your client over here or the third party will send money to an account in euro, either the account that the customer has with the PSP or the PSP has with the UK bank. You will then most likely receive money into the GBP account over here and send it out to a third party or to the customer. So provided this third party over here has the account based in the UK, then below this line, you will be deemed to be the sending PSP. This payment falls within the rules. Above this line, this payment will not be within the FPS payment rules because this is a money remittance payment. It is not a credit transfer. It's not from the customer's relevant account with the sending PSP. It's from the PSP's account with the financial institution. So this payment falls within the rules. This payment does not fall within the rules. Again, I just emphasize, make it clear in your terms, which payments fall inside and which payments fall outside. So I just thought I'd talk through some upcoming deadlines. There's a UK Finance webinar on the 12th of September. 16th of September, the directory set up on the RCMS platform onboarding access. On the 18th of September, the PSR consultation paper on the new cap of £85,000 closes. So reply to that if you want the cap to be reduced to £85,000. 20th of September is the deadline to sign the RCMS contract. 7th of October is obviously whenever the rules come into place. On the 1st of December is when the first entry for new reporting is open. And 6th of January is when the deadline for reporting standard A is there. So what can we do to help? I've talked a lot about updating terms and conditions. We can do that. We specialize in that. We've done that for customers already. We've given a lot of thought to what should go into terms and conditions to protect PSPs to the maximum extent possible without, going too far and breaching consumer duty, because you have to live within the rules. But as far as I'm concerned, consumer duty doesn't change the rules. The various government bodies have decided what the rules are. It's not up to us to go further than that. I wouldn't think. If you haven't already done so, then you should update your website. You should build interruptions into your online platform. We can help you with that by putting wording on your website. We can obviously help you with the terms. What I've done for a few clients is that they have sent me a detail of all the payment flows that they actually execute. And I have, given my opinion on which ones fall within the FPS reimbursement rules and which ones don't. And that really has allowed them to hone in on where they need to concentrate all of their efforts and enhance due diligence on when payments are being made. Because a lot of FX and payments firms obviously send money overseas. There's not so many, depending on your business model, obviously, GBP to GBP payments within the UK, unless you're a receiving PSP. So we can look at your payment flows and tell you actually where is your risk in relation to the reimbursement rules for faster payments. That can help you frame your own internal policy and what you're going to do to reduce your risk and to help your consumers basically not fall victim to app fraud. But point 4 is obviously like a legal opinion, setting out which payment flows that you execute fall within the FPS reimbursement rules and which don't. That's part of sort of building your internal policy. So if you enjoyed that talk, you've got my link to the Calendly, hopefully in the chat. We'll send it out after the event anyway. My email address is here. If you would like to email me, if you have any queries, I'll be delighted to help.